This is Michael Popok with a Legal AF Hot Take. We're continuing to watch this cat and mouse game between Jack Smith, the special counsel, and Judge Aileen Cannon, the Southern District of Florida judge, who is presiding over the Mar-a-Lago espionage and obstruction of justice case. Over 40 counts of felony counts against Donald Trump and his co-conspirators. What am I talking about? Well, let's just say that they don't get along when it comes to how documents should be filed, when documents should be put on the public record, when classified and secret documents should be revealed to the public at all, and the fact that the judge has slow walked the case so that the motions to dismiss about the indictment that was filed over a year ago, the hearing on one of them or two of them is just happening on the 14th of March. I'm not making this up. And then when the judge set the hearing, and she set a hearing for March 14th to hear several of the motions to dismiss that Donald Trump has filed, he's filed about 7 or 8 of them. She's only given herself like 2 hours of time. I'm not making this up, to read the final papers related to each of the motions filed by the parties. So in her docket, and the docket is a very strange place. It's almost like Aileen Cannon has an allergic reaction to managing her docket. Usually it's not this difficult. But for her, she sort of created a side secret docket of her own making, because she requires now the parties to give her the motions and give the other side the motions before they're even docketed on the court. This is a judge who proclaims with great fanfare that she is a believer in the transparency related to criminal justice system and the public docket. Yet she has created an intranet, if you will, where she's not allowing Jack Smith to file his motions on the public docket. Or on the other hand, she's forcing him to file confidential information on the public docket, which of course he cannot and will not do. But this little secret sideshow, send me the motion. You're not supposed to send the judge a motion or what you're supposed to just file it. Your communication with the judge, frankly, even in a case like this involving Classified Information Procedures Act, is supposed to be through the public docket, redacted and sealed appropriately to protect confidential information, classified information, the names of confidential witnesses who participated in the grand jury process, not keeping the information from the other side in order to hamper their defense. You're just keeping it from the public and the prying eyes until the appropriate time. So Judge Cannon not only has set up this sort of don't docket anything, send it to me first for me to approve, which creates an inordinate burden on the prosecution. And now the prosecution and the cat and mouse game back have just said, you know what? We're not going to wait around for Judge Cannon to look at what we've sent her to approve it for docketing. We'll just docket it. You know, they had a fight over the judicial use of the jury questionnaire. And rather than go back and forth, Jack Smith said, screw it. We'll just docket it, the jury questionnaire. They didn't want to docket the jury questionnaire so the public could see it, so that potential jurors couldn't game the system, know what the questions were going to be in advance so they could come up with the right answers to get on the jury, right? Then you've got, like a potential for a runaway jury. You got somebody who's actually trying to get onto a jury because they know the answers to the questions in advance. The test answers and questions have been posted by the professor. They didn't want to do that, but because of the way Judge Cannon is forcing them to, and has created this shadow secret docket, they have to. And now we have a new order that I can't make heads or tails out of, and I've been practicing for a long time. She said we're going to hold the non-evidentiary hearing in her order on certain motions to dismiss filed by Donald Trump, including this ridiculous one arguing that the charges against him are based on a law so vague as applied to him that they should be dismissed. His argument is, well, I was president and I had some security clearance through the Energy Department. I had a Q clearance. That was a shout out to his QAnon people. And in addition to that, the Presidential Records Act covers me in certain places, and the top secret clearance covers me in certain places. And I may have mentally ripped off the classified and declassified documents. So somewhere in there, in that little gray area, it's very vague. You shouldn't be prosecuting me. I mean, that in front of any other seasoned judge, and certainly the 11th Circuit, is not going to prevail. But she's going to hold an evidentiary hearing, Judge Cannon, on the 14th of March. But the confusing thing is she's giving herself very little time to hear the full argument, because she's forcing the reply papers, just to go back over how you fully brief a motion. The motion gets filed by the movant, this case Donald Trump, on his motions to dismiss. There's an opposition paper that comes in the middle. That's in this case by the government, by the special counsel. Then there's a reply paper. That's by the movant, so Donald Trump again. Each one of these motions to dismiss, they're all separated, means there are 3 total briefs, 2 by Donald Trump and 1 by the government in the middle. She's just ordered that the reply papers by Donald Trump come in at 8 a.m. on the 14th of March, while the hearing is at 10 a.m. So she's going to do a final read, an hour and a half or so, over a cup of coffee before one of the most momentous decisions she needs to make in what could be the trial of the century of a former president about espionage and obstruction of justice. She's given herself all of 120 minutes to get prepared and read the cases and understand the cases and be ready for questions for a full day evidentiary hearing. I don't know if it's just crazy or if it's like crazy like a fox. I don't know if she's got an ulterior motive to help Donald Trump by making him file so late and she's going to deny them anyway, or she's just bending over backwards to do things procedurally incorrectly in order to drag out the case so that there's no way on God's green earth it gets tried before the November election, which is looking more and more like the behavior. This is not the conduct of a judge who is efficiently trying to move this case forward to its effective trial date before the election, even though she set a date so that nobody can take pot shots at her. This indictment, motions to dismiss, should have been filed 9 months ago, 10 months ago, just like they were in the D.C. election interference case. The motions to dismiss are about the indictment. The indictment was generated or issued by the grand jury a year ago. Motions to dismiss about what the indictment says in the 4 corners of that piece of paper should have been done back then, not on the eve of the trial, not leaving enough time for an appeal process up maybe to the United States Supreme Court. And that's where we are right now.
What's more important than sleep? It's the foundation of our mental and physical health. And when you're sleeping well, you can perform at your best in every way. Proper sleep can also increase focus, boost your energy, and improve your mood. Introducing Beam's Dream Powder. It's a science-backed, healthy hot cocoa for sleep. If you know me, you know that Dream has been a game changer for my sleep. Sometimes I find myself up at night in bed with thoughts, uneasiness, going on my phone. Well, that was the case until I started drinking Beam's Dream Powder. Prior to this Dream Powder, the poor sleep and late nights staying up affected my mood and affected my energy, but not anymore. And today, our listeners get a special discount on Beam's Dream Powder, their science-backed healthy hot cocoa for sleep with no added sugar. It's now available in many different delicious flavors. It's really good, like chocolate peanut butter, cinnamon, cocoa, and sea salt caramel with only 15 calories and 0 grams of sugar. Better sleep has never tasted better, and other sleep aids can sometimes make you feel groggy the next day. Take it from me, I have tried them and they do, but Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, and melatonin and nano CBD to help you fall asleep, stay asleep, and wake up refreshed. The numbers don't lie. In a clinical study, 93% of participants reported that Dream helped them get better sleep. Beam Dream is easy to add to your nighttime routine. Just mix it in hot water or milk, froth, and enjoy before bed. Find out why Forbes and New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, get up to 40% off for a limited time when you go to shopbeam.com/legalaf and use legalaf as a code at checkout. That's shopbeam.com/legalaf and use legalaf, the code, when you check out for up to 40% off.
These are not the motions to dismiss Donald Trump wants to raise. He wants to raise presidential immunity. The problem is he's not the president of the United States when these things happened. He was already out of office. And so his attempts to use even what he sees as a favorable possible ruling by the Supreme Court is severely limited. But what to make, and we're going to put it up on the screen, what to make of this order, this strange order this strange order which Aileen Cannon said that I'm going to hold the hearings on the unconstitutional vagueness and the dismissal of counts 1 through 32. And I'm also going to talk about whether the Presidential Records Act somehow dismisses the indictment or provides Donald Trump with a defense, which was also raised by Walt Nauta. I don't know how Walt Nauta could raise the Presidential Records Act. Given the indictment's very intense allegations about Donald Trump's obstruction of justice, hiding boxes, hiding documents from the Department of Justice, from federal judges, from magistrate judges, from subpoenas and search warrants from his own lawyers, and giving direction and using henchmen within the Mar-a-Lago and members of his staff to hide boxes and documents, instructing his lawyers to destroy evidence, to rip up incriminating material that's in the folders before they produce it to the government. I don't know how on God's green earth Aileen Cannon could even think about dismissing anything. Maybe that's why she's only giving herself 120 minutes to get the final briefing in, understand the case, and hold the oral argument. But I doubt it. With everything down in Florida, where I practice regularly, this is dumbfounding. This is maddening. This is frustrating. And all we can do is bring it to you here and tell you what I think. What I think is going on is that she is, at least for these particular motions to dismiss, she's inclined to deny them. So she's giving Trump very little time. But there are other motions to dismiss that go to the heart of the case that she's not yet scheduled. And why hasn't she? She's already said she's not going to try the case in May, take it off the docket. She says that July is too soon. She's wondering if August is enough time. And Donald Trump has said, let's do it in 2025, when we can all get back together after a presidential election. So we need to follow all things that happen and try to be as transparent as possible in our analysis about Aileen Cannon down in Florida. We do it on the MeidasTouch Network's Legal AF, only on this YouTube channel, and then on our Wednesday and Saturday podcasts. We call, you guessed it, Legal AF, at the intersection of law, politics, and justice. You like lawyers who know what they're talking about on podcasts about law and politics, you've come to the right place. I'm Michael Popok. I co-anchor the show on Wednesdays and Saturdays, again, 8 p.m. Eastern time. And then we do hot takes like this one about every hour at the intersection of law, politics, and justice. And you can show your support by leaving a comment and a thumbs up. It really does help. It's not ego. I mean, let's be frank. There's a fair amount of ego in what we do on Legal AF and the MeidasTouch Network. We couldn't get in front of a camera and a laptop and a microphone and do this regularly if we didn't have a healthy a sense of self, let's just put it that way, and confidence. However, we hopefully are doing it for good and for justice and for democracy. And the way you can contribute is easy. Thumbs and fingers, comments, and thumbs up. And the algorithmic gods read that and say, yeah, we like this show. It's a popular show. Let's keep the show on the air. And the whole big ecosystem just works because we are the network that you are helping to build. No outside investors, grassroots. You know, to paraphrase Barack Obama, you are the change and the network you were looking for. And we appreciate you being here with us for the ride. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.